My son handed me a stack of business documents across my own kitchen table and said, "Dad, this is your chance to finally do something that matters." When I told him I wouldn't sign, he filed a lawsuit claiming I owed him $350,000. The judge asked to see one piece of paper. What happened next, my son never saw coming. The morning I found out started like every other morning since I retired. 6:15, coffee before the sun cleared the tree line. The newspaper still delivered the old-fashioned way, because I never saw the point in changing what works. I'd put in 31 years as a civil engineer with the county, spent the last 8 managing infrastructure contracts that most people never thought about until a bridge needed fixing or a drainage system backed up. I was good at reading plans. I was better at spotting when something didn't add up. My son pulled into the driveway at 8:30 on a Thursday in September. I hadn't heard from him in 6 weeks. Not since a birthday call that lasted 4 minutes and ended when he said he had a meeting. He came alone, which surprised me. Usually his wife, the one he'd married 3 years earlier, and who had never once looked me in the eye for more than a second, was attached to his side at every family occasion. He came around the back porch the way he had since he was a teenager, knocked twice, and walked in before I answered. Old habit. I used to find it charming. "You look good, Dad." He set a leather portfolio on the table. Expensive looking. The kind with a zipper all the way around. "Retirement agrees with you." "Coffee?" I was already reaching for a second mug. "Sure." He sat down, unzipped the portfolio, and started pulling out papers. "I've been wanting to talk to you about something. Big opportunity. The kind that only comes around once." I set his coffee in front of him and sat across the table. The papers he laid out were dense with numbers. Balance sheets. Projections. A cover sheet with a company name I didn't recognize. Cornerstone Equity Partners. He walked me through it fast, the way salespeople do when they've rehearsed, and don't want you to think too long between sentences. He and 2 partners had identified a commercial real estate opportunity in the Nashville area. Office to residential conversions, he said. Huge demand. The market was perfect. They needed a capital infusion of $350,000 to close the deal before another buyer stepped in. He'd already committed his partner's shares. He just needed one more investor. He looked at me across the table. "I've been building toward this for 3 years. This is the one." I picked up the top sheet and looked at it the way I'd looked at thousands of engineering specs. I wasn't a financial analyst, but I understood how numbers were supposed to behave. What I saw didn't behave the way it should. Revenue projections that started vertical, operating costs that barely changed as the company scaled, a market analysis that cited no sources. I set it down. "How much have you personally put in?" He shifted in his chair. "I've contributed my share of the planning, the relationship building, the due diligence. That's what I bring to the partnership." "That's not what I asked." He looked at the ceiling for a moment. "Dad, I need you to trust me on this one. You have the savings. You told me yourself your retirement accounts are fully funded. This money is just sitting there. Let it work." I wrapped both hands around my coffee mug. "You're asking me to give $350,000 to a company I've never heard of based on projections, without sources. I'm asking you to believe in your son." The silence between us felt like something being stretched. "I'm not going to do that," I said. His face changed. Not dramatically, not like in the movies. Just a subtle tightening around the jaw, a cooling behind the eyes. He gathered his papers slowly, which I recognized as a performance. The slow gathering meant he wanted me to feel the weight of what I was passing up. "You know," he said, standing, "I've spent my whole life watching you protect your money instead of your family. Mom used to say the same thing." That one landed harder than he probably knew, because he walked out before he could see it. My ex-wife and I had divorced 18 years earlier, civilly enough, and she'd remarried and moved to Scottsdale. My son had always positioned himself as her ally in the unspoken ledger of who had failed whom in that marriage. I had accepted that. What I hadn't accepted was having it weaponized across my own kitchen table. I locked the back door after he left, something I didn't usually do during the day, just felt right. The lawsuit papers arrived 11 days later, served at the front door by a process server, who handed me the envelope and was back in her car before I'd finished reading my name on the outside. The complaint ran 18 pages. It alleged that I had entered into a verbal partnership agreement with my son and his business partners, that I had repeatedly promised over the course of several years to provide capital support when he was ready to launch a serious venture, and that he and his partners had relied on those promises to their detriment by turning down other investors. They were seeking $350,000 in damages plus legal fees. The total demand at the top of the document read $412,000. I sat at the kitchen table where he'd laid out his portfolio 12 days earlier and read every page twice. Then I made myself a sandwich I didn't eat and called my neighbor 2 streets over, a retired attorney named Harold who played poker with me the second Friday of every month. He answered on the first ring. "Harold, I need a name. Civil litigation. Someone who handles contract disputes and knows elder law." He didn't ask many questions. He gave me 2 names and told me to call the second one first. Her name was Diane Kurtz. She was 50-something, ran a firm out of a converted house on the east side of Chattanooga, and had spent 15 years in commercial litigation before going private. She met me the following Tuesday. Her office smelled like coffee and old paper. She read the complaint standing up, which I took as a good sign. People who read standing up are actually reading. They're claiming oral contract and promissory estoppel. She set the document on her desk. In Tennessee, oral contracts over $500 have to meet a pretty high bar to be enforceable. They need to show a clear offer, clear acceptance, and actual reliance. What they filed is a hope and a prayer dressed up in legal language. Can they win? She looked at me directly. Anyone can win anything if the other side isn't prepared. Are you prepared to fight this, or are you looking for a quick exit? I thought about my son sitting across my kitchen table, telling me my money was just sitting there. I'm prepared to fight. Diane put a legal pad in front of her and clicked her pen. Then start talking. I want every interaction you've ever had with your son about money. Every email, every text, every conversation you can remember. We're going to build a timeline. I had more documentation than she expected. I'd always been a records keeper, same instinct that had made me good at managing contracts for the county. I had 7 years of bank statements. I had emails going back to 2017. I had a folder of text messages I had screenshotted because my son had a pattern of saying things in writing that contradicted what he said in person, and I'd started keeping track 2 years earlier without fully understanding why. This is thorough. Diane flipped through the printed emails. You have a message here from 3 years ago where you explicitly tell him you're not in a position to fund a business venture without seeing a full audited plan. That's the opposite of a promise. He knows that message exists. Then he's counting on you not finding it. She set the folder down. He may not have expected you to show up with homework. The weeks that followed had a particular quality to them. The lawsuit had pulled a curtain back on something I had been half seeing for years. My son had a talent for expensive things. The truck he drove was newer than anything I'd owned in my working years. The house he and his wife had bought was 4 bedrooms for 2 people in a suburb where the HOA fees alone ran $300 a month. I'd always attributed it to the modern way of living, young people spending money differently than my generation had. Now I started to wonder. I called a private investigator through a referral from Diane. His name was Arthur, and he operated out of a strip mall office that looked like it hadn't been updated since 1994. He asked me blunt questions and wrote the answers in a spiral notebook. What are you looking for? He said. I want to know if my son has the financial standing to actually be in a business partnership, or whether he's coming to me because there's nowhere else to go. Arthur charged me a flat fee, told me 10 days, and delivered in 8. He came by the house this time, sat at the kitchen table, and opened a folder that he placed face down first, the way a doctor sometimes does, before showing you a scan. Your son's credit score is 541, he said. He has 2 personal loans currently in collections, an outstanding balance on a business credit card that was opened 6 months ago and has been maxed since month 2. His mortgage is 63 days past, due as of last month. He paused. His business partners in this cornerstone venture both have similar profiles. None of them have the resources to close a commercial deal. They don't have another investor. They never did. He turned the folder over. The documents were organized by category, the way I would have organized them myself. The business plan they showed you, Arthur continued, I had a colleague in commercial real estate look at the Nashville property they referenced. It sold 4 months ago to a different buyer. Whatever they pitched you was built around a deal that was already gone. I held the bank records in my hands and felt something clarify. Not anger exactly. Something colder. The lawsuit wasn't about a business opportunity I'd refused to join. There was no opportunity. There had never been one. My son had constructed a story around a non-existent deal, shown up with professional-looking documents. And when I'd said no, he'd filed suit to take what he couldn't convince me to give voluntarily. I called Diane from my car in the driveway and read her the key points from Arthur's report. "This changes the character of the claim significantly," she said. "We're not just defending against a breach of oral contract. We're showing that the contract itself was based on a fraudulent premise. Tennessee has strong provisions against civil fraud, and given your age, there may also be grounds under the Adult Protection Act." "My age," I said. "Specifically targeting someone over 60 with a scheme designed to extract assets. That's elder financial abuse under Tennessee law. It can carry criminal penalties." She paused. "I need you to think carefully about whether you want to pursue that angle. It escalates things considerably." I looked through the windshield at the front door of the house I'd paid off 11 years ago. "Escalate it," I said. The texts started arriving that same week. My son at first, reasonable in tone, suggesting we could still resolve this between us. Then his wife, who I'd never received a direct message from in 3 years of marriage, she wrote that I was tearing the family apart, that my son was under enormous stress, that I had resources I wasn't using while they were struggling. Then my son again, less reasonable. Old grievances surfacing. References to my divorce, to working too much, to being emotionally unavailable. The texts came in clusters, usually after 10 at night, which told me something about when he was making these decisions and what state he was in when he made them. I documented every one of them without responding. Diane had been clear on that point. Don't engage. Don't explain. Don't defend yourself in text messages. Every message he sent without response was a record of him talking to himself. On a Wednesday morning, I ran into an old colleague from the county engineering office at the hardware store. We'd worked together for 12 years before he moved to the private sector. He was buying PVC fittings, and we talked for 10 minutes in the plumbing aisle. Near the end of the conversation, almost as an aside, he mentioned that he'd run into my son a few months back. He was at a financial seminar, he said. One of those investment things they hold at the convention center. He was working the room pretty hard, talking to anyone who'd listen about this Nashville deal. "I thought about calling you, but I figured you knew." I didn't know. I thanked him and drove home with the image of my son circulating through a conference room, pitching a deal that had already closed, to anyone he could buttonhole. I had been one name on a list. Probably not the first one. Possibly not the last. I brought that information to Diane's office with Arthur's report and the text messages printed out in chronological order. She spread them across her conference table and stood back. "He didn't come to you because you were his father," she said. "It wasn't a question. He came to me because I was the only one left who might say yes." She filed the counterclaim the following week. We alleged that the original lawsuit was frivolous, that the claimed oral contract never existed, that the business premise was fraudulent, and that the conduct constituted attempted financial exploitation of an older adult under Tennessee statute. The counterclaim sought recovery of my legal fees and referral of the matter to the state attorney general's office for further review. Patricia Morrison, my son's attorney, fired off an angry letter demanding withdrawal. Diane sent back a polite single-page response declining. My son called me 3 days after the counterclaim was filed. I let it go to voicemail. He called again that evening. I listened to the message once. His voice had a quality I hadn't heard in years, something fraying underneath the words. He said the lawsuit had gotten out of hand, that he hadn't meant for things to go this far, that if I would just talk to him, maybe we could figure something out. I didn't call back. 2 weeks before trial, his attorney filed a motion requesting I meet with them privately to discuss settlement. Diane reviewed it and shook her head. Morrison is a contingency attorney. She takes cases she thinks will settle. She's starting to realize this one won't. She tossed the motion on her desk. They'll offer you something. Probably try to make you feel like you're getting a win by accepting 50 cents on the dollar of their original demand. I don't want 50 cents. Good. Then we let the judge decide. The morning of trial, I wore the charcoal suit I'd bought for my retirement ceremony. It still fit. I'd walked 4 miles every morning since I left the county, and retirement had been good for my waistline if nothing else. Diane met me at the Hamilton County Courthouse at 8:30. She was calm in a way that I recognized from the best engineers I'd worked with, the ones who were most thorough precisely because they understood that thoroughness was what kept things from going wrong. My son was already inside with his wife and their attorney. He wore a suit that was slightly too large in the shoulders, which was the kind of detail I noticed because I'd spent 30 years reviewing drawings where every measurement mattered. His wife sat beside him and studied the table in front of her. Neither of them acknowledged me. The judge was a woman in her mid-60s, named the Honorable Catherine Whitmore. Her reputation, which Harold had helped me research, was that she ran a tight courtroom and had no patience for cases that wasted her time. My son's attorney opened with the performance I'd anticipated. Devoted son, broken promise, years of assurances that had shaped major life decisions. She was a capable speaker, and she made the story sound almost plausible. Almost. Diane did not go to the podium when it was our turn. She walked to the display screen connected to her laptop and brought up the email from 3 years ago. The one where I had explicitly told my son I would not fund a venture without an audited plan. It filled the screen large enough to read from the back of the room. The plaintiff claims my client made repeated promises over several years, she said. This is what my client actually wrote. She moved through the evidence the same way I would have walked a client through an engineering deficiency, methodical. Each piece explained before the next one appeared, the bank records showing no transactions that supported the claimed promises, the text messages showing my son's escalating pressure after I'd refused. Arthur's findings on the Nashville property already sold before the pitch was ever made. The credit reports, the collections, the missed mortgage payments. Morrison objected twice. Judge Whitmore sustained neither objection. When Diane presented the evidence regarding the Adult Protection Act, Morrison started to rise from her chair. Judge Whitmore held up one hand and Morrison sat back down. Judge Whitmore removed her glasses and looked past both attorneys. She looked at me. Mr. Harlow, she said. My name in a courtroom felt strange, weighted. I have one question for you. Did you ever make any kind of promise, formal or informal, to provide your son with capital funding for a business venture? Every eye in the room turned. My son's jaw tightened in my peripheral vision. I stood. Old habit from 30 years of presenting to county boards. Your Honor, I said, I made no such promise. What I did promise 30 years ago was to put him through college, which I did, to make sure he had a stable home, which I did, and to leave him a fair inheritance when I'm gone, which my will reflects. What I never promised was to fund a business built around a property that had already been sold to someone else 4 months before he walked into my kitchen. The room was quiet for a moment. That's what I thought, Judge Whitmore said. She turned toward the plaintiff's table. Her expression wasn't theatrical, just measured, the way experienced people look when they've seen something confirm what they already suspected. Counsel, I've reviewed the evidence submitted by the defense. I have serious concerns about the premise of this lawsuit. Morrison stood. Your Honor, the plaintiff's position is that oral assurances were given over a significant period of time. I heard your opening statement. Judge Whitmore's voice didn't rise. It didn't need to. What I'm looking at now is a document showing the Nashville property your client's venture was built around closed escrow in May. This lawsuit was filed in September. She set the document down. I'm going to need the weekend to review the full record. We'll reconvene Monday. The gavel came down and the room exhaled. My son pushed back from the table immediately. His wife was already gathering her bag. They moved toward the exit fast, the way people move when they want to be somewhere else before anyone can say anything to them. Morrison was on her phone before the courtroom door closed behind them. Diane walked with me to the parking garage. The October air was sharp and clean after the recycled cool of the courthouse. The question she asked you, I said. She knew what she was doing. She'd already made up her mind on the merits, Diane said. That question was for the record. She wanted your answer documented. She stopped at her car. Monday, I expect we get a full ruling. Go home and rest. You've done the hard part. I drove home the long way, through neighborhoods I'd known for 30 years, past the park where my son had played Little League 2 seasons in a row before losing interest, past the high school where I'd sat in the bleachers watching him graduate, past the church where his mother and I had stood together a long time ago when things were still simple. By the time I pulled into my driveway, I was tired in a way that had nothing to do with the hour. Winning didn't feel the way I thought it would. It just felt like the end of something that should never have started. Monday came cold and overcast. I dressed in the same suit, same drive, same marble hallway. My son was not in the courtroom when I arrived. His wife was not there. After 8 minutes, Morrison walked in alone, sat at the plaintiff's table, and began arranging papers with the focused attention of someone who doesn't want to make eye contact with anyone in the room. Judge Whitmore entered at 9 sharp. She read her ruling from the bench without theatrical pause. The complaint was dismissed with prejudice. No credible evidence of an oral contract, no documentation of reliance. The claim of promissory estoppel failed on every element. My counterclaim was granted. My son and his partners were ordered to pay $15,200 in legal fees within 45 days. Then she said the part that made Morrison stop arranging her papers. Based on evidence presented, this court is referring this matter to the Tennessee Bureau of Investigation and the State Attorney General's Office for review under the Tennessee Adult Protection Act. The court finds sufficient cause to believe that the original complaint may have been filed as part of a scheme to extract assets from an older adult through fraudulent misrepresentation. She set the ruling down. Court is adjourned. The gavel. I sat for a moment after everyone else started moving. Diane touched my elbow and I stood. In the hallway, I found out why my son had not been in the courtroom. He was standing near the elevator bank with his wife, and from the look on their faces, they'd heard everything through the door, or been watching a live stream, or been told by text. His face was the color of old chalk. His wife was crying quietly. When he saw me, he straightened. I walked toward them and stopped a few feet away. His wife looked at the floor. "You built a lawsuit around a property you knew was gone," I said. My voice came out level. I hadn't planned a speech. I just decided that if I saw him, I would say the true thing. "You didn't come to me because you had an opportunity. You came to me because you'd run out of options. I was the last name on your list." He didn't say anything. His jaw moved once. "I would have helped you," I said. "If you'd come to me honestly and told me you were in trouble, I would have found a way to help. That was still possible until the moment you chose lawyers instead of a phone call." I turned and walked toward the exit. Diane fell into step beside me. The criminal referral moved through channels I mostly didn't follow. Diane kept me updated in brief phone calls. The Attorney General's office opened an inquiry. The 2 business partners who'd been named in the original filing negotiated quickly, paid restitution to cover the documented misrepresentation to a small number of other people they'd also approached. My son's case moved more slowly because his situation was more complicated, and his attorney was working harder. In January, I drove to the estate attorney I'd used when I drafted my original will. I sat across the desk from him, and we spent 2 hours revising the document. The new will directed 60% of my estate to a regional foundation supporting financial literacy programs for adults over 60. My son would receive 20%, reduced from the majority he'd previously been named. A condition attached required that it be held in trust until he reached 55, administered by a third party. The remaining 20% went to a nephew I had always been close to, my late brother's youngest son, who had never once asked me for anything. "This is clearly a deliberate choice," the attorney confirmed as he notarized the last page. "The trust condition is enforceable and specific. This will hold." Driving home, I felt something settle into place. The same sensation I used to get when the final drawings on a complex project passed inspection. Everything accounted for. Everything in its proper position. The letter came in March. I recognized his handwriting on the envelope, the same loose, left-leaning print he'd had since grade school. I stood at the mailbox for a moment before going inside. I made coffee before I opened it. It was one page. He didn't begin with an excuse, which I had expected, or an explanation, which I had dreaded. He began with, "I know what I did." 4 words, plain and undecorated. He wrote that the partnership, the pitch, the lawsuit had all been his idea, that he'd convinced his wife it was legal and that I would eventually see reason, that he told himself for months that the Nashville deal was real enough and his intentions good enough to justify the pressure he was applying. He wrote that watching the judge refer the case to the Attorney General had been the moment he stopped being able to lie to himself. He didn't ask me to call him. He didn't ask for anything. He wrote that if I ever wanted to have coffee sometime, he'd understand either answer. I read it twice, folded it carefully, put it in the desk drawer where I keep documents that aren't resolved yet, the ones that might still need something done with them someday. I walked 4 miles that afternoon through the neighborhood, the same route I'd walked since the Monday after I retired. The maple trees along Ridgecrest Drive were just starting to show new green. A dog barked at me from behind a fence, the way it always did, then wagged its tail through the gaps, the way it always did after. The ordinary world, going about its ordinary business. I didn't know yet whether I would write back. That wasn't the decision I needed to make in March. Some things can wait until they're ready. I'd spent 31 years in a profession that taught me the difference between a problem that needed solving right now and one that needed the right conditions before it could be properly addressed. This was the second kind. I climbed my porch steps and went inside to start the rest of the day. What I keep coming back to, months after the gavel came down, is how close I came to simply writing the check. Not because I believed the pitch. I didn't. Not even in the first 5 minutes. But because he was my son. And there's a particular kind of pressure that comes from someone who knows exactly which doors in you are still unlocked. He knew about the divorce. He knew about the years I'd worked late. He knew which words would find the soft places. And for a moment, across that kitchen table, I felt the pull of it. The idea that maybe signing was easier than carrying the weight of having said no to my own child. I'm glad I didn't give in to that. Not because of the money, though $350,000 is not nothing to a man living on a county pension and 30 years of careful saving. I'm glad because giving in would have been a lie. It would have told him that the way he behaved was acceptable, that manipulation dressed up in a leather portfolio was a reasonable way to treat a person, even a person who loved him. What the lawsuit taught me, what I had to learn the hard way at 64 years old, is that integrity isn't something you practice in easy moments. It doesn't cost you anything to be honest when honesty is convenient. The real test is when someone you love is sitting across from you, using your own history against you, and you have to decide whether the truth is still worth telling. I told it. It cost me months of legal fees and more sleepless nights than I'd had since my working years. It was still worth it. The intelligence part, and I don't mean book learning. I mean the discipline of actually thinking clearly when emotion is pulling hard in another direction. That's what Diane recognized when she walked into her office and found me with 4 organized folders. Arthur recognized it too, the way he handed over his report and said, almost approvingly, that the documentation was thorough. I'd spent 31 years reading plans and flagging discrepancies, and that habit didn't retire when I did. When my son laid those projections on my table, I didn't just feel wrong about them. I looked at them. I asked the question he hadn't prepared for. That one question, about how much he'd personally put in, was where the whole structure cracked. Because he couldn't answer it, and we both knew it. And then there was just the matter of not quitting. The texts kept coming. The family pressure built. There were nights I sat at my desk and read through the whole file again, just to remind myself it was actually true. Because the version of events he was spreading to the family was convincing enough that I occasionally felt it pulling at me. Staying the course when someone is actively rewriting the story of who you are requires something more than confidence. It requires a willingness to be misunderstood for as long as it takes for the facts to speak. The facts did speak. Judge Whitmore heard them. The Attorney General's office heard them. And somewhere in that, I think my son heard them too. Finally, in the only language that had ever gotten through to him when words hadn't worked. Consequences. Real ones. The kind that don't negotiate. I don't know yet what happens next between us. The letter is still in my desk drawer. Some things take longer than a season to figure out, but I know who I am when it matters. That's not nothing. At 64, after everything, that turns out to be quite a lot.